And all of us would like to know more about what she did and what she said and why she did it. That is not the issue before us today. The issue before us today is, even with non-heroic figures, especially with non-heroic figures, did the Bill of Rights encompass the right of every citizen, even an IRS employee, to avoid self-entrapment? Mr. Jordan, our friend from Ohio, cited James Madison of my state of Virginia. And he's absolutely right. James Madison put a lot of credence in the power of Congress and felt that's where it belonged. In fact, believed that the people's body, the House of Representatives, really kind of trumped even the courts with respect to interpretation of constitutional issues and legislation. But that same James Madison had to be persuaded, and was persuaded, as the very first act in the first Congress to adopt a Bill of Rights. Now, there could have been 100 enumerated rights. They enumerated 10. And the fifth one was the right against self-incrimination, for a reason. Because what had characterized colonial times and what characterized, frankly, British 17th century jurisprudence was the Star Chamber proceeding, in which somebody's words could be used against them and against their will. Are we going to now insist on the Miranda right recitation for every witness who comes before this committee? By the way, anything you say can and will be used against you, so say nothing. Are we going to throw out case law? Unfortunately, what we're about today brings us right back to the McCarthy era, not as a name, but if you want to look at case law, that's where you have to go. That's the last time Congress trampled on rights, citizens' rights, unheroic citizens. And the Quinn case is dispositive. It deals with precisely what's in front of us. The fact that someone prefaces their remarks with a protestation of their innocence and then invokes the Fifth Amendment right is addressed many times by court cases, including by the Supreme Court of the United States in Quinn. And it explicitly says that does not waive your right. For the majority of this committee to assert otherwise is conveniently to ignore case law. In tough times, in tough cases, I plead with my colleagues on the other side of the aisle. Are we not about protecting citizens' rights, even when they're not particularly appealing characters? It's precisely when it's difficult, it's precisely when it's politically inconvenient and unpopular that this body must rise to the occasion and protect the constitutional rights of everybody. Because when we jeopardize the rights of a citizen like Lois Lerner, we put in jeopardy the rights of every American. I have seen so often people hold up the Constitution saying, I am first a constitutionalist. Well, then practice what you preach. Look at that Fifth Amendment and understand what it means. And cast the right vote today, which is against this Star Chamber proceeding. I yield back.
Thank the gentleman. Members are advised that we will not recess for the vote, which is currently going on the floor. So if they need to vote and come back, I'd advise them to. We will call members in the order in which they ask to be recognized when they are present. With that, we go to the gentleman from North Carolina, Mr. McHenry.
Mr. Chairman, point of order on that, on the procedure.
The gentleman will state his point of order.
So when a member goes down to vote, you will not close out the discussion part of this thing while they're
No, that's what I just said. We'll look forward to your return, Mr. Tierney. The gentleman from North Carolina.
Mr. Chairman, thank you. We have a serious matter before the committee today. We've, both sides of the aisle, been able to go through hundreds of thousands of pages of documents. And one thing is clear. Lois Lerner orchestrated a concerted effort to target conservative groups because of their political views. The other thing that's clear is here in Congress, there are liberal members of the House and the Senate that wanted to use the IRS to target conservative groups because they didn't like a court case, including some on this committee. My Democrat colleague referenced Miranda rights. Well, one thing is clear from all the documents about Lois Lerner is that she's going to understand her Miranda rights. If we have accountability, if we have the rule of law in this country, and if those law enforcement agencies actually look at the evidence that we have before us. So what we're doing today should have been done months ago, but because it was the concerted effort of this committee and the majority party on this committee to make sure we got all the evidence and we did not act in haste. We've had 11 months of investigation on this. This thing started almost 4 years ago. So the actions we're taking today are justified based off of the evidence we have today. And my Democrat colleagues certainly appreciated the targeting that Lois Lerner was doing for them within the IRS. But it was their party that was targeted by a Republican president 40 years ago. And how things have changed in 40 years, that those very folks that were targeted are trying to use that very same bureaucracy to target those that they oppose in political speech and debate. I'd like to yield the balance of my time to the gentleman from Ohio.
I thank the gentleman for yielding. I wanted to go back to our colleague, Mr. Lynch, and the statement I read earlier that he made 2 weeks ago in our committee hearing. Remember the context of that statement. The context was Mr. Koskinen had told this committee that we might not get all of Lois Lerner's emails for 2 years. And Mr. Lynch said, that's not appropriate. We need that information. And then he quoted, and I'll quote him again, and then he said, and I'll quote him again, the very powerful agency the IRS is, with a lot of information on a lot of individuals, has been targeting citizens. That's serious stuff, and I think that justifies the scopes of the committee's inquiry and the urgency to get those emails. So here's the key question. If Lois Lerner won't talk to us and the IRS won't give us their emails, how in the heck are we going to get to the truth? That's why this resolution is so important. It's on strong legal ground. We have that analysis. But from a practical standpoint, the only way we're going to get to the truth about the targeting of people's most fundamental right, their right to speak out politically, is if we can use every tool at our disposal to try to compel Lois Lerner to sit on that witness stand and answer our questions so the American people can get the truth. And that's why Mr. Lynch was spot on 2 weeks ago when he said this is of such paramount importance. We've got to get that information because it's about the First Amendment. Mr. Chairman, with that, I would yield back. Or yield back the time to the gentleman from North Carolina.
And I'd be happy to yield the...
I thank the gentleman for yielding. There's been a lot of testimony here by members. I would advise that on any referral, the statements made by members are, in fact, part of what is likely to be part of the record. So when members are stating what did or didn't happen, I would admonish them to ensure that that they also provide for the record such documents as may be appropriate to further their point. At this point, we now recognize the gentlelady from California, Ms. Spear.
Chairman, thank you. This is not a proud day for this committee. I oftentimes wonder if we weren't on a 24-hour news cycle, whether we would conduct our business differently. Chairman Lankford and I, as ranking member of a subcommittee yesterday, held a very important hearing about Social Security disability and waste and abuse and fraud. But here, this is a spectacle that's been orchestrated to obscure facts that aren't partisan and won't put political points on the scoreboard. The hallmarks of a politically motivated and biased investigation have been evident throughout this process. The majority announced the conclusion of the investigation before they held one hearing or conducted a single interview. In fact, the chairman of this committee went on Fox News and announced that there was a conspiracy and that the President of the United States, the White House, had been involved in this fiasco. Facts that haven't fit into the predetermined narrative of the majority have been completely ignored. There have been 31 legal experts that have spoken out on whether or not Ms. Lerner waived her rights. Now, the chairman and others have called them our lawyers, but we have not hired them. And they come from across the political spectrum and across the country. Let's take, for instance, Professor Patrice Volcker of John Marshall Law School, who said, quote, "Launching a contempt prosecution against Ms. Lerner appears futile and superfluous due to the committee's disregard for long-standing traditions of procedure." Andrea Dennis of the University of Georgia Law School said, quote, "A contempt prosecution would be legally and factually unsupported." Well, here are the facts. In the last 60 years, what has been required for a group to qualify as a 501c4 status mutated from being exclusively for a social service or social welfare purpose to what today is incomprehensibly interpreted as any group that is primarily dedicated to social welfare causes. The result has been a flood of groups operating contrary to the spirit of the law for seeking and being granted tax-exempt status. Second, groups seeking to file as a 501c3 or 4 aren't even required to go through the certification process that has been derided by the majority. Groups can file as a 501c4 without certification. Nothing requires these groups to face the supposed gauntlet of the IRS's certification process. They can avoid that process altogether and self-certify. Third, what has become clear is that an under-resourced IRS took inappropriate and ill-advised shortcuts to try to get through thousands of 501c4 applications. The IRS took inappropriate and ill-advised shortcuts to identify conservative and liberal groups that potentially didn't qualify for tax exemption because they weren't primarily involved in social welfare purposes. What has also become clear from this exhaustive investigation is that today is not about Lois Lerner or the alleged inappropriate tactics she may have employed. Today is about protecting the integrity and the credibility of this committee. The truth is that Lois Lerner is a mid-level bureaucrat who may have made some poor decisions. Whether she is found in contempt or not, her name has been dragged through the mud and her bank account has been drained to pay her lawyer's fees. From the outset, the chairman has been seemingly convinced that not only Lois Lerner, but the White House and President Obama have orchestrated a vast conspiracy to punish conservative 501c4s. After millions of dollars have been spent on a taxpayer-funded witch hunt, this is where we have ended up. There is no connection to the White House. What we are trying to do is hold in contempt a mid-level bureaucrat, and the actions of this committee won't hold up to judicial scrutiny. If this vast conspiracy had been real and not fantasy, Lois Lerner would have been offered immunity on day one. The only way to build a conspiracy case is to grant immunity to smaller players to get to larger ones. This could have turned out very differently. Lois Lerner was willing to testify and wanted one additional week because her lawyer was going to be out of town, and we didn't give it to her. Shame on us. I yield back.
I thank the gentlelady, and I'll yield myself for just a minute to respond to a couple of things that have been said. First of all, this hearing is, I think, a proper hearing because we have an individual who has had every opportunity to cooperate from nearly a year ago when she was first brought before this committee. She first professed her innocence and then took the fifth. We brought her back several weeks ago, and we offered an opportunity. The chairman sat in this chair, questioned her again. Repeatedly, she exercised contempt to the committee process, exercising her Fifth Amendment right, which she has the right to do. I might remind everyone that this is not something, again, initiated by our side of the aisle. In fact, I cited and showed where the Inspector General got started a month after 7 Democrat senators had exercised their concern and wanted investigation of what was going on with IRS and some of these groups. So the Inspector General acted with the due process, did a thorough investigation. We've heard a number of attempts to close this down unfortunately, by the ranking member. It's all over. We didn't need to go any further. And yet, we have failed even to this hearing on this day to receive simple document requests. The gentlelady mentioned the cost of taxpayer funds. We had recently the new IRS commissioner who said he gave us 400,000 pages of documents. He could give us, as I said at that hearing, 1 billion pages, but if they are not what we requested, and he spends taxpayer time, expenses, and resources in just blanketing the committee with information we didn't request. We've requested specific emails from Lois Lerner, which we still haven't gotten. What you've seen here is what we've pieced together. What you've seen here is also our talking to witnesses, all who point towards Lois Lerner. Lois Lerner, as I documented, went before the American Bar Association just before the Inspector General's report was released in almost a Hollywood production. I said earlier worthy of an Academy Award. She tried to cast the blame on folks around the water cooler, low-level IRS employees in Cincinnati. And again, they felt that they were not only thrown under the bus, they were thrown under a Mack truck convoy. So it's very clear that the person held in contempt here, and we've been most patient, more than, well, we're going on a year, because it will be a year in May, that we have requested the cooperation of this individual. And she can't selectively thumb her nose at the Congress and the American people and hold us in contempt and not be held in contempt. So we have a responsibility as a committee to move forward. She has been given the opportunity and, again, thumbed her nose at the committee. With those comments, I'm pleased to yield to Mr. Lankford for 5 minutes.
Thank you, Mr. Chairman. This is what we're dealing with today. Can an individual make a statement, appear to waive their right to the Fifth Amendment, and then decide, no, I'm going to go ahead and plead the Fifth anyway? What does that mean to go ahead and say, I'm not going to speak based on self-incrimination? We lose track of how this really started. May the 10th of 2013, Lois Lerner had a question planted at the ABA conference so that she would be asked about something that was completely irrelevant to that day, and so she could leak out that day about this rogue group in Cincinnati and what was happening. 12 days later, she was in front of this committee. In front of this committee, she made this statement. Good morning. Members of the committee, my name is Lois Lerner. I'm the Director of Exempt Organizations at the Internal Revenue Service. I've been a government employee for 34 years. I initially practiced law at the Department of Justice. In fact, she was the staff attorney in the criminal division of the Department of Justice, and later at the Federal Election Commission. In fact, she was in the General Counsel's office at the Federal Election Commission. And then she goes on to make this long statement. In the course of this statement, she said this: I have not done anything wrong. I have not broken any laws. I have not violated any IRS rules or regulations. I have not provided false information to this or other congressional committees. I know some people will assume I've done something wrong. I have not. I have responded to questions about the IRS processing of applications for tax exemption. All these statements that she made, in fact. And then there's this statement, but I'm going to invoke my Fifth Amendment privilege so I don't have to answer questions related to these statements that I just made. Here's our big concern. You waive your right to Fifth Amendment when you make statements of fact about yourself. In this belief that she was not aware or didn't know, she'd practiced law for years. She had been general counsel at the Federal Election Commission. She had practiced law in the criminal division of the Department of Justice. This is not someone who was not aware of the law. This is someone who was very aware. We're asking a simple thing: answer questions. This entire investigation points back to one person beginning to answer questions. Why is this such a big deal? Well, somewhat it's a big deal because of the questions she was asking others to give. Now, I brought with me a copy of a letter that was sent by her office to one of the Oklahoma Tea Party groups. In this letter, she outlines at the beginning of it from their office that under penalty of perjury, everything has to be correct, and reminds the people that fill this out that everything you give me will be made public. So make sure what you give me, you're okay with being public, because I will release everything that you put in this document. And then this person who stands up and says, I don't have to answer questions, I don't have to make anything public, though I can make assertions that I've done nothing wrong, asked the individuals in Oklahoma that had simply applied for this application. They asked, give me a transcript of any speeches given by any candidate at any of your meetings. How about this? Do you directly or indirectly communicate with members of legislative bodies? If so, provide written communications and contents of any form of any other communication. This person that says, I do not have to say anything, required of them the contents of private conversations with any legislator that they might have come into contact with. They also asked, please state whether you provide any advocacy training for your members to the general public. If yes, describe in detail your advocacy training. Provide copies of any publications concerning your training. How about this one? Who selects the material on your website? Name them. And how do they set criteria for that? Describe in detail your advocacy training. Provide copies of anything related to your training. Provide copies of all your corporate minutes from its inception to the present. Provide copies of your website, the areas that only members can access. This is private information that they're requiring of private citizens. They're requiring, if you're going to come through our office, we're going to make public every conversation you've had with any legislator you've ever communicated with. Write us in detail the nature of that communication. Yet this person says, I can require someone else to do those things, but you can't require me to speak even after I've made a statement that I've done nothing wrong, I've violated no rules, I've told this committee the truth every time. I can make those statements, but I don't have to back it up. You do have to back it up. You cannot step into this committee, make an assertion of fact, waive your Fifth Amendment right, and say I won't answer questions, while at the same time requiring organizations for years, some of them, like this one, still waiting for their tax-exempt status, and say they have to do it, but I don't. We're Americans. We're all treated the same. This is not treating someone different. This is treating everyone the same. So it's time we get some answers. With that, I yield back.
I thank the gentleman. Let me yield now to the gentlelady from Illinois, if she's ready. Ms. Kelly.
Thank you, Mr. Chairman. Chairman Issa has missed multiple opportunities for this committee to obtain information that would help our inquiry. Last month, her attorney sent a letter to Chairman Issa offering to provide a proffer to the committee detailing what Ms. Lerner would say if called to testify. Strangely, instead of accepting this offer, the chairman went on national television and claimed that this written offer never happened. He said this, and I quote, "We want to get to the truth. If the attorney had a proffer, which, as you know, which would be to tell us, don't tell us your client is innocent, tell us what we need to know," and he never offered to do that. The chairman never obtained a proffer, and when the ranking member tried to ask about it at the hearing in March, Chairman Issa cut off his microphone and closed down the hearing in one of the worst examples of partisanship this committee has ever seen. The chairman did something similar when Ms. Lerner's attorney offered to have her testify with a simple one-week extension since he had obligations out of town. Rather than accept this offer, the chairman decided to go on national television and declare inaccurately that she would testify without the extension. That inaccurate statement ended up scuttling the offer as Mrs. Lerner counsel lost all faith in the credibility of this committee. As I listen to my Republican colleagues argue in favor of this resolution, I am left to wonder if they realize how we got here. The chairman failed to obtain a proffer. He scuttled an offer to obtain Mrs. Lerner's testimony. He kept Democratic members out of negotiations with Mrs. Lerner's attorney. And when the ranking member has attempted to help the chairman get the information he says he wants, the chairman silenced the ranking member and prevented him from speaking. I can only assume that despite his repeated claims, the chairman doesn't actually want to hear from Ms. Lerner. And that's a shame, because the public deserves the truth, not a political sideshow. I yield back.
Pleased to yield to the gentleman from North Carolina, Mr. Meadows.
Thank you, Mr. Chairman. And as we go into this particular debate, I think it's good for all of us to remember that this is a debate on a motion, a debate on perhaps amendments that may be offered. And as we start to look at this, the question of Lois Lerner being held in contempt is one that both sides of the aisle should take very seriously. But it really gets down to restoring the trust for the American people. What we have found over and over again is, starting last May, is someone who came before this very committee and said that she had done nothing wrong. Since that time, almost a year now, we have found emails and discovered emails where over and over again it would indicate that that particular statement was not true. Her own attorney, speaking to the Wall Street Journal, talked about the reason why she didn't want to come here and testify is because she would be, quote, vilified. Well, when you start to look at this, and if that indeed is the reason, where we have found her to have talked to the Department of Justice, talked to reporters, talked to other people, and her only reason for coming here is because she does not want to be vilified. Indeed, that is unfortunate. But being vilified is not a constitutionally protected event. Certainly invoking the Fifth, if she had said nothing, would have been proper. But yet to come in and suggest that she has done nothing wrong, Mr. Chairman, and then go further with that to say that the reason she is not coming forth to testify before this oversight committee is troubling, because the American people deserve the truth. Those organizations who were targeted, some for well over 3 years without a decision, need to have the truth come out. You know, we still have some of these Tea Party groups today that are still waiting on decisions. And that is unfortunate when you have one of the most powerful agencies in the country that is not willing to make a decision when by statute they're required to make a decision within 270 days anyways. And yet somehow a deadline for the IRS is not one that they have to adhere to. And yet when the shoe is on the other foot, and when we have an American taxpayer that has a deadline that they're enforcing, they somehow have a double standard. That deadline must be met, and yet the IRS continues to not meet their deadlines. I want to close with this, that perhaps this didn't need to take place today if the IRS commissioner and those that are in charge of Lois Lerner's emails had been more forthcoming. The average American person does not understand why we could not have all of Lois Lerner's emails delivered to us in over a year's time. I don't understand it, and you would think that that would be a very simple request. So with that,
Will the gentleman yield his balance of his time?
Sure, I'll yield the balance of my time.
Well, again, I think the gentleman points out in his closing minute that he has left. Let me remind again the committee and this contempt proceeding of the facts. The facts are that in February 2011, Lerner sent an email to her staff advising them that cases involving the Tea Party applicants were very dangerous. This is, again, in February of 2011. She was there. She was orchestrating this. We know that much. Carter Hall, who came before us, the veteran IRS official who worked the test cases in Washington, testified that Lerner's senior advisors told him the chief counsel's office would need to review the Tea Party application, something he had never seen done in his 48 years at the IRS. These are the facts. Lois Lerner has had several opportunities to come before this committee and tell us the whole truth and nothing but the truth, and she failed to do that. She should be held in contempt, and I'm pleased to yield now to the gentlelady from Illinois, Ms. Duckworth.
Thank you, Mr. Chairman. I share your frustration that Ms. Lerner chose not to testify. This is the same frustration that all members of this committee has. She has valuable information and important questions that she must answer about the mismanagement of the IRS. I personally would like to understand why Ms. Lerner failed to inform Congress about the inappropriate targeting sooner. I would also like to ask Ms. Lerner about the gross mismanagement that created an atmosphere in which the targeting could continue for so long. Despite the hyper-partisan attention this issue has received, I think that there are important lessons to be learned here to make sure this type of targeting never happens again. But as members of Congress, we are sworn to uphold the Constitution, and I take this oath very seriously. I first took this oath when I joined the Army in my early 20s, and for the past 25 years of my life have upheld it. I did the same when I swore in as a member of Congress. Ms. Lerner has a constitutional right to plead the Fifth, and anything that calls into question a citizen's constitutional right should be held to the highest degree of scrutiny. I'm not a legal expert, but this committee was provided with numerous opinions of those who are legal experts from both conservative and liberal political philosophies, and they unanimously conclude that Ms. Lerner did not waive her Fifth Amendment rights. This committee should not be in the business of stripping away the constitutional rights of an American when there is so little substantive debate and zero evidence. This type of reckless action has not been taken by Congress since the days of Senator McCarthy and the House Committee on Un-American Activities. Mr. Chairman, my constituents do not want Congress to go back to the McCarthy era. I cannot support this effort to drag us into one of the darkest periods in the history of this institution. I ask again that we recognize that Ms. Lerner did indeed invoke her Fifth Amendment rights, and I yield back.
Would the gentlelady yield?
I do yield.
I appreciate the gentlelady's comments, and as such a great member of the committee, I would appreciate to just make one point. Many have referred to the late Senator McCarthy. I hope that the gentlelady would view this a little differently. Essentially, we are faced with competing views as to whether or not somebody taking the Fifth and then continuing to answer questions, or speaking the material fact not considered by any of the 31 witnesses that I've seen paper on, whether or not those witnesses or those experts considered her speaking to the Justice Department thoroughly. As several members of the Democratic side here have said in their statements, she was willing to testify but then changed her mind for reasons other than self-incrimination. These are all issues that will, if we refer this contempt motion, be heard by a Federal judge. And the point of today's markup is, do we send to a Federal judge for his or her consideration, with a U.S. attorney involved, the question of did she waive? And I might suggest to all our members, at least in this member's opinion, since there is a debate, House counsel has issued the Chair his opinion that she waived. Other experts are on the other side. I, like you, am not an attorney. So the question today is, do I believe, based on advice of the counsel that I am supposed to use, which is the House counsel, who is a nonpartisan, that there is sufficient reason to move contempt through the House and then ultimately have the question decided by a lifetime appointment U.S. Federal judge that I won't get to pick and you won't get to pick? And I think the answer should be yes. So hopefully the gentlelady will consider before final vote, are we in fact asking the question of should a Federal judge decide this based on And you're free to say you don't think she waived. That's fine. But I think the question is, should an independent arbitrator decide what I've been told by House counsel was, in fact, a waive that should entitle us to at least ask questions as to the things she testified to after she evoked the Fifth, things like that document that you saw her say was true and correct. And I thank the gentlelady so very much.
Would the gentlelady yield further?
I will yield to the ranking member.
Yeah, it's just, and this is to the gentlelady, this is the very reason why I asked that experts come in, legal experts, to give us their opinions, because this is a very weighty issue, and we do have lay people on both sides, and I thought it would have been beneficial, but we were denied that. Thank you very much.
I thank the gentlelady. I thank the gentleman. We now go to the gentleman from Utah, Mr. Chaffetz.
I thank the gentleman. I'd like to yield to the gentleman from South Carolina, Mr. Gowdy.
I thank the gentleman from Utah. Mr. Chairman, you have an absolute right to remain silent. No inference or suggestion of guilt may be inferred from your invocation of that right to remain silent. However, if you do testify or take the stand, you will be treated like any other witness and subject to cross-examination. Mr. Chairman, the reason that that phrase is running through my mind is because I heard it for 16 years. It's being repeated in courtrooms all across this country today, but not for powerful people that work for government, just for everyday folks. Just for everyday witnesses or everyday defendants of petty crimes, not charged with violation of constitutional rights, maybe just petty larceny. But they're being told you have a right to remain silent. However, if you testify or take the stand, you will be treated like every other witness. Mr. Chairman, I counted 17 separate factual assertions by Ms. Lerner, not those 3 little sentences that my colleagues like to cite, 17 separate factual assertions. That is a lot of talking for somebody who wants to remain silent. That's a lot of talking. If you honestly believe that you can make 17 separate factual assertions and still invoke your right to remain silent, then please tell me what waiver is. Please tell me what constitutes waiver if saying 17 separate factual things does not. Mr. Chairman, she testified, I have done nothing wrong, I've broken no laws, I've broken no IRS rules or regulations. That's her testimony. What I'm saying is we should have the right to cross-examine her on that testimony. Because I'd like to ask her, when you said we need a plan, who is we and what plan are you referring to? When she said we need to be careful that it's not perceived as political, who is we and what are you concerned about the perception of politics for? What are you fearful of, Ms. Lerner? She said, I think we really need to do a project. Again, Ms. Lerner, who is we and what project are you referring to? That is a legitimate question. And every brother and sister at the bar on the other side of the aisle would ask that question on cross-examination if given the opportunity. Can you imagine, Mr. Chairman, can you imagine a fact pattern where somebody takes the stand and says, I didn't rob the bank, but I'm not going to answer why my fingerprints are on the demand note, and I'm not going to tell you why I'm on the surveillance footage with the gun in my hand, and I'm not going to tell you why the dye pack blew up in my car. I'm just going to tell you I didn't rob the bank. That's not the way our system works. You have to answer the other side's questions. I think these questions are fair. The Tea Party's very dangerous. Dangerous to whom? Who, Ms. Lerner? Who thinks they're dangerous? You? The IRS? Dangerous in what way? We need a vehicle to get back to court. Who is we? Why do you want to get back to court? Could it, heaven forbid, be because you don't like Citizens United? Is that possibly the explanation? Mr. Chairman, she said Cincinnati should not have these cases, but then she turned around and said Cincinnati was to blame. That's an inconsistent statement. Every lawyer on that side of the aisle would ask her to explain that inconsistency. Everyone. So why can't we? If this isn't waiver, then can someone explain to me on the other side what fact pattern constitutes waiver? If you can, make 17 separate factual assertions and authenticate a document and say, I have done nothing wrong, which is about as broad as any testimony can possibly get. I've done nothing wrong. I've broken no laws. I've broken no rules or regulations. I mean, honestly, what testimony could be broader than that? So necessarily, our cross-examination should be equally broad, and it would be in a courtroom. How often did you use your personal email, Ms. Lerner? That's a fair question. The Committee on Ways and Means just referred that issue to the Department of Justice. How many times did you use your personal email? When you mused about applying for a job with an organization connected with the President, were you kidding, Ms. Lerner? Or were you serious? We know you were contemplating retirement. Were you really seriously going to work? Mr. Chairman, I know my time is up. I'm just going to say this in conclusion. The same Constitution that allows her the right, if she wants to sit there and say nothing, allows these groups the right to petition their government for redress.
I appreciate the gentleman. The gentleman's time has expired. Who seeks recognition? Mr. Cartwright.
Thank you, Mr. Chairman. Mr. Chairman, I'd like to join in the Ranking Member Cummings's objecting to this resolution, not because we don't want to hear from Lois Lerner. We do, and I join Mr. Gowdy in saying I'd love to have a crack at cross-examining her myself. But I object to this because it is a trampling on individual rights, something that we are sworn to uphold and protect in this country. You know, the Chairman referred to McCarthyism, and several members here today have done that. You know, a lot of people in the United States were not born when Joe McCarthy was running around half-cocked, as he did, trumping up charges against individuals that they were communists and plotting to conspire against the United States government, holding up lists and claiming to have their names in his hands, piecing together random bits of information, cherry-picked from this source or that source. That's what he did, and Mr. Chairman, that was a national embarrassment. It was a national embarrassment. You know, there are a lot of reasons people want to come to this nation from all over the world, principally because we are the bright, shining beacon of liberty in this country, and we can't just make that a phrase for lip service. We have to make it real. To make liberty real, we have to have civil rights in this country. This was a dream of our founders. That's why they cooked up a Bill of Rights, and right smack in the middle of that Bill of Rights is the Fifth Amendment. And sometimes, I agree with Mr. Gowdy, we don't like it when they assert the Fifth Amendment, because a lot of times the people who make that assertion are not the model boy of the village. We get that. But it is a right that we cherish here in the United States because it prevents things like what Mr. Connolly was referring to, the star chamber, where people would be dragged in, tortured, forced to testify against themselves, and then incarcerated because of that. We didn't like that when it happened, and we don't like it now. Now, I want to say, this is a Bill of Rights that was brought up by our Founding Fathers, but it's a Bill of Rights that since then, brave men and women in this nation have fought, bled, and died for. It is not something lightly to be tossed away just because we're mad at an IRS employee. And so I join in the Ranking Member's objection to this proceeding today. And I also want to meet Mr. Gowdy's challenge when he says, can you imagine a situation? We don't have to imagine a situation where somebody invoked the Fifth Amendment after making a brief statement. That happened during the McCarthy era in United States versus Hogue, H-O-A-G. There are striking similarities here. In that case, during a hearing on August 6, 1954, Senator McCarthy repeatedly questioned a lady from Cheektowaga, New York, near Buffalo, named Diantha Hogue. Despite the fact that she had asserted her Fifth Amendment rights, Diantha was a coil winder at Westinghouse Company in Cheektowaga. She made $1.71 an hour. She professed her innocence, just the way Lois Lerner did, and then declined to answer subsequent questions. In response to questioning from Senator McCarthy, for example, she stated, "I have never engaged in espionage nor sabotage. I am not so engaged. I will not so engage in the future. I am not a spy nor a saboteur." Like Chairman Issa here, Senator McCarthy concluded that his witness had waived her Fifth Amendment rights without citing any independent legal opinion or experts. He explained to her that she had waived her Fifth Amendment right, and then she was brought up for criminal prosecution. That prosecution was thrown out in court, and that's in the precedents. And so I say there is precedent for this, and there's also a procedural defect because it was not demanded of Lois Lerner that she answer the question despite her protestation and her assertion of the Fifth Amendment. So this is not a conviction that could be held up in court, no matter how much anybody wants it to. I don't fault, I know the Chairman is not a lawyer, and I don't fault him for an imperfect understanding of the law, but you don't need to be a lawyer in this country to understand fairness.
The gentleman's time has expired under the Jefferson rules. We now go to the gentleman from Michigan, Mr. Walberg.
I thank the Chairman, and I thank you for continuing this process. It's a process that is worth continuing. It's a process that, sadly, has been hampered all along the way, and then today we hear a series of talking points that I think move away from what the real issue is, and that's the facts that we deserve to have on this committee to carry out the responsibilities that have been given to us under oath of office were not given. Now, there are lawyers in the room on both sides, and there are lawyers in courtrooms on both sides. And there's disagreements on what the law says, what the Constitution means all the time. But on this committee, it is our responsibility to carry out the authority of the oversight of every agency, every program, every department, every bureaucrat, if necessary, of government to make sure that the people are being served well. Talking points only go so far. Reality is the concern here, and when we had a person who, as my colleague from South Carolina said so adequately, gave a defense and then was unwilling to be cross-examined, we have a problem. This government is unique. And I would that we would not forget the purpose of the People's House that this committee works for. Alexander Hamilton said, when a question was questioned about this government, he said, "Here, the people govern." We are the people's representatives. And people are asking questions on why they, as normal, law-abiding citizens that had political beliefs, were being targeted. They deserve those answers. We are the people's representatives. Thomas Jefferson said, "When the people fear their government, there is tyranny. When the government fears the people, there is liberty." How in the world can we reverse that to the point that the government does fear the people when we have a non-elected bureaucrat who targeted, by the record, targeted individual citizens for their political beliefs and get away with it? How can we carry out the advice of Thomas Jefferson? And finally, Mr. Chairman, John Adams said, "Liberty lost once is liberty lost forever." We run that risk. If an IRS bureaucrat can strike fear in the hearts and minds and actions of people so that they won't even use their First Amendment liberties without worries that their names will be taken down, we have a problem. And that problem is a loss of liberty. And so, Mr. Chairman, I applaud you for continuing this process with all sorts of pitfalls in the way, with all sorts of hurdles put in the way, with all sorts of talking points put up to obfuscate what the truth is. And I would that we, the People's House, would remember that. We serve the people. We represent the people. They deserve an answer. And the bureaucracy ought to respond to them and not the other way around. And I yield back.
I thank the gentleman. Who seeks recognition? Mr. Davis.
Thank you very much, Mr. Chairman.
Mr. Davis, I apologize. Mr. Davis is recognized.
Thank you, Mr. Chairman. Like many of us, I serve on 2 committees, and I serve on the Committee on Ways and Means. And yesterday, of course, we made a criminal referral of Ms. Lerner to the Justice Department by the Ways and Means Committee, which I voted against. And I voted against it because I felt that it was nothing more than a stunt to promote the House Republicans' political narrative. The Justice Department is already conducting a criminal investigation of Ms. Lerner and the Internal Revenue Service's conduct identified in the May 2013 Inspector General's report, and the Department already has access to the sensitive taxpayer information released yesterday by Ways and Means. If this referral, as my Republican colleagues claim, was intended simply to draw Department of Justice's attention to certain key documents, Chairman Kemp could have done it privately, but he did not. He made a public spectacle of it the day before our committee's vote on contempt. Our ranking member, Levin, explained that the last time Ways and Means took an unprecedented step of making sensitive tax return information public was back in 1974 in an audit of President Nixon's tax returns. So in the course of 2 days, the Ways and Means Committee hearkened back to the days of Nixon when it released sensitive information, and our committee will take a McCarthy-era, as many people have already indicated, contempt vote. It is my feeling that these partisan public spectacles erode the credibility of this House, and it gives people more cause to wonder if the House is really looking for the information that all of us talk about, or are we playing politics with each other and the American public? I think the Justice Department is fully capable of doing its job, of doing its work, of ferreting out the information that is needed, and I think we ought to let them do it, and I yield back, Mr. Chairman.
The gentleman yields back. We now go to the gentleman from Arizona, Mr. Gosar.
Thank you, Mr. Chairman. I would like to start by saying that although my friends across the aisle have accused the majority of a partisan witch hunt, such accusations are completely unfounded. The common adage is, facts are stubborn things. I contend that all one must do is to reflect on the facts, to know that this investigation is about asserting what happened. So let's analyze the facts. We know that Lois Lerner has a history of favoring liberal groups over conservative groups, a bias. There were multiple instances during her tenure at the Federal Elections Commission that show that, and I'd like to place into the record an article outlining such of these instances.
Without objection, so ordered.
We have documents and emails from Lois Lerner with phrases like, I'm really thinking we need to do a C4 project next year, and we need to have a plan. We need to be cautious so it isn't per se a political project. We know that Ms. Lerner sent official IRS emails to her unofficial email account, which is a violation of IRS rules. We also know that she may have broken Federal law by disclosing sensitive tax return information. We know that she was heavily involved in the orchestration and disclosure of the information to the public about inappropriate tactics used by the IRS. She wanted to avoid litigation, that being disclosure forum, because, as she put it, if it goes to litigation, all details are public, no guessing needed. So it seems Ms. Lerner wished to stay away from litigation in court so as to avoid having all details of these issues from becoming public. These facts lead one to assume that this could be the same motive she used when withholding information from Congress. We also know she lied or misled this committee on numerous accounts. We asked her whether the criteria for evaluating tax-exempt applications had changed at any point. Ms. Lerner responded the criteria had not changed, but it had. In 2012, she told this committee that the information the IRS was requesting in letters to conservative tax-exempt applicants was not out of the ordinary. But on May 13, 2013, that also was refuted. In fact, a 48-year-old veteran of the IRS said he never once had seen such applications go to the Chief Counsel's office. We also know former IRS Acting Commissioner Steve Miller told us that the IRS was under, and I quote, tremendous pressure from Senator Carl Levin to implement new regulations, end quote. So considering all of this, why would this committee cease its efforts to get to the truth? Why should it? Constitutional rights were infringed upon by the government, and it is our job to get the American people answers. So you see, without Ms. Lerner's full cooperation and without immunity, neither this committee nor the American public will have the answers it needs from its government. Now, the Ways and Means Committee has voted to ask the Department of Justice to take Ms. Lerner to court for orchestrating the targeting of these political groups, disclosing taxpayer information, which is a felony, and obstructing these ongoing investigations. So after going over these steps and the facts, I would like to ask my colleagues across the aisle to tell me how it is that you can legitimately argue that we can conclude this investigation. Is it because the President says so? Is it because the Ranking Member Cummings has said so? How about Attorney General Eric Holder? Is it because there is a piece of evidence out there that totally absolves Ms. Lerner and all officials at the IRS from these wrongdoings? If so, why hasn't the minority shared these documents with the majority so that we may move on to other important oversight matters? If this truly is a waste of time, prove it to us and we can move on. Until then, I recommend my friends across the aisle quit crying foul. But when, not if, but when we get to the bottom of this, I hope there will be no one on the other side of the dais who will be determined to have obstructed the pursuit of justice. I would like to close by saying that I personally find no pleasure in today's proceedings. I do not find pleasure in holding Attorney General Eric Holder in contempt. I do not enjoy holding any Federal official in contempt of pursuing criminal charges. Doing so means we have a government run amok, and such a situation is a lose-lose situation for all citizens, regardless of political beliefs. As uncomfortable as it may be, it is our job to proceed. Actions have consequences. I am simply a firm believer in the rule of law and the responsibility of Congress, and specifically this Oversight Committee, to ensure that the Federal Government operates in a manner that the public sees fit. Our government, in this case the IRS and the Justice Department, are in a sad state of affairs. This should be a turning point to restore justice and accountability, both in the person and in the government institutions. Institutions granted authority by the people to serve and protect people, not abuse them. I support the Chairman in his pursuit of justice and accountable government, and I will support the resolution holding Ms. Lerner in contempt. And with that, I yield back.
I thank the gentleman. We have been advised that the next round of votes may be together 2 votes. Therefore, I will continue the hearing as long as possible, recess in order for people to make both votes, and then return immediately following the second vote if they call 2 votes. Without that, the gentleman from Massachusetts, Mr. Tierney, is recognized.
Well, thank you, Mr. Chairman. Mr. Chairman, this is wrong on so many levels here today that we're debating, the actual credibility of this committee, and somehow we turned a very unsympathetic figure into somebody who has now become the focal point of whether or not her constitutional rights have been violated. And in a sense, when everybody that I imagine on this committee wanted to hear her testimony and get to the bottom of the facts of this matter, we're now looking at the very best we're going to get delay in litigation and maybe prevented from getting that information at all. And that's just an injustice done to this committee and injustice done to the American people who count on this committee to run those investigations in an impartial and professional manner. Like my colleague, I suspect that if the Chairman is not a lawyer, that he can't be held responsible for knowing how these legal matters set up. But the time to have consulted House counsel was not after the fact, when the House counsel is put in a position of defending who is going to be their client down the road. But the time to consult it was when it looked like these things were going to become an issue. And if that's the case, then we would have known that numerous impartial experts now tell us that Ms. Lerner did not waive her Fifth Amendment rights. But beyond that, regardless of that legal issue, it's clear that after Chairman Issa failed to follow the minimal procedural safeguards that have been required by the Supreme Court as a prerequisite for a contempt charge, we're now in this situation. The experts are clear. At no point was the witness directed to answer, and accordingly, no prosecution will lie. So that's a sad situation. But worse than that is, having botched the process, earlier on there was also botched an opportunity to get a proffer of what she would have said had she been granted immunity. Now, I know that the Chairman raised the issue of immunity sometime back last May, and after he did that, I know that the ranking member said, well, wait a minute, let's take a proffer. Let's see whether or not granting immunity would make sense before we deprive this committee of all of its responsibilities here and all of its evidence on that. And then that was botched. And so we missed the opportunity to move forward on that basis, and now we're into this indefinite delay and problem that we have. And this committee is once again put into the public light of not being a committee that is acting in the way it should be professionally and responsibly on that basis. And all the mentions that you heard of McCarthyism around here on this side weren't out of thin air and weren't concoctions of members of this committee. Unfortunately, that's become a public perception. And that's unfortunate. We are on this committee ostensibly because we believe the work can be done and we can get to the bottom of the facts regardless of who's in the White House. It's our job as Congress to make sure that every agency and every department carries out the law and spends the money that's been appropriated in the manner in which has been intended by Congress. We should be protecting Congress, the people's house, and making sure that those things are done. But let me just tell you what the public perception is out there as an example in some of the publications. I quote, without putting too fine a point on the premise, ICE's semi-certitude seems to echo the late Senator Joe McCarthy's assurance that he had papers proving there were 205 communists in the President Eisenhower's State Department without a shred of evidence offered by the accuser. If there is a White House link, let's see it before insisting it's there. And that's the Chicago Tribune. And there's been a lot of insistence of things there, a lot of quoting of materials that aren't even on the record, and a failure or refusal by the majority and by the Chairman to release the transcripts so that would perfectly give the public an idea of what's going on. Another quote, Mr. Iser's investigations closely resemble Senator Joseph McCarthy's 1950s red baiting. Mr. Iser is copying Joseph McCarthy in 3 ways. First, he is using a legislative committee to pursue his personal mission, to stop people he thinks are destroying democracy. Second, Mr. Iser has accused people without having conclusive facts. Third, Mr. Iser has tried to let only his views be voiced in his committee. That's the Times Standard in a letter to the editor. Another quote, through a campaign of innuendo and half-truths, he, Iser, has smeared one of the world's most efficient tax agencies. Since that time, he has conducted a series of hearings on a witch hunt against the IRS and its employees, the likes of which have not been seen since Senator Joe McCarthy ran the Senate Un-American Activities Committee in the 1950s. He has selectively released portions of the transcripts that support his narrative of an alleged scandal and cover-up without releasing the portions that rebut that flawed theory. Again, another quote, in one brief and repugnant interview, the GOP's chief congressional investigator into Internal Revenue Service abuses cherry-picked evidence, overstated his case, and violated the sacred American principle of presumed innocence. Do you hear history's echo? Senator Joe McCarthy paved his way to infamy with 205 names. That's the National Journal's editorial. And another, I quote, but as the new Congress is seated, Iser and his GOP colleagues should note the difference between investigation and witch hunt. Too often in our political history, the former has turned into the latter. But he now has the whip in his hand, and the investigative power, as we have so many times in American history seen, it can be grossly abused. Washington Post. And I have more, Mr. Chairman.
And if you had more time, I'm sure you would use it. We would now go to the gentleman from Pennsylvania, Mr. Meehan.
Thank you, Mr. Chairman. Mr. Chairman, I have consistently listened to the representations of my colleagues on the other side invoking McCarthy. I want to be clear that McCarthy was acting in a manner in which he was challenging the beliefs of other people. Here, we are not challenging the beliefs of other people. We are challenging the actions, the alleged actions of Lois Lerner, in which she used the forces of her governmental agency to impact the civil rights and beliefs of American citizens, and that is a distinction. The issue here is really quite simple, apart from all the politics. We are making a fundamental legal analysis. The question isn't whether, as has been invoked many times, whether she is being denied her right to the Fifth Amendment. The question is whether she waived that right. And I submit the answer is unambiguous. This is not an unsophisticated woman. This is a woman who has testified she herself is an attorney from the Department of Justice who came before this committee with very learned counsel. And she chose to make an opening statement in which, among other things, she proclaimed she had done nothing wrong, she had broken no laws, not violated any IRS rules or regulations, not provided false testimony or information before any other congressional committee. She waived her Fifth Amendment privilege by providing voluntary opening statements in which she testified to matters before this committee. It is that simple. And that is the question we are asking. She submitted to a lengthy interview at the Department of Justice without immunity, but will not testify before this committee because, as my colleague Mr. Meadows pointed out, her attorney asserts she is fearful of being vilified. That is not a standard which allows one to refuse to comment before this committee. Third, there is a line of questions being raised by counsel, by my learned friends on the other side who are suggesting the Quinn case stands somehow for the principle that she has been denied a right before this committee. The simple principle of the Quinn case is clear. It relates to whether a witness has been clearly apprised that this committee was demanding answers notwithstanding the witness's objections, and whether she has to determine and make a choice about what the committee is requesting of her. That is the Quinn case and the trilogy that follow it. But in this case, there's absolutely no ambiguity. Lerner wasn't forced to guess what the committee's ruling was. She was left to guess at nothing. Her own attorney acknowledged that she understood that the committee voted that she had waived her rights. The Quinn case is entirely unrelated to this issue. Therefore, the simple conclusions can be drawn. There's no constitutional impediment to this committee's approving a resolution which recommends that the full House hold Mrs. Lerner in contempt. I conclude by stating the simple facts before us. Mrs. Lerner refused to comply with a congressional subpoena. Second, her testimony is vital to this committee's investigation into this very legitimate matter. Third, she offered a voluntary statement and appearances before this committee. Fourth, this committee determined that she waived her Fifth Amendment privilege. Fifth, Mrs. Lerner, in line with the Quinn cases, was clearly informed of that decision, and still Mrs. Lerner continues to refuse to testify before this committee. I submit to my colleagues on both sides of the aisle, all the constitutional impediments have been removed. It's a clear and simple question before us. This committee should recommend to the House that Ms. Lerner be held in contempt for failure to comply with the subpoenas issued to her. I recommend that my colleagues on both sides of the committee vote accordingly.
I thank the gentleman. We now go to the gentlelady from New Mexico, Ms. Grisham.
Thank you, Mr. Chairman, and I'm going to yield my time to the ranking member.
I want to thank the gentlelady for yielding. Mr. Chairman, I'd like to put into the record 2 letters. Over the last week, I received 2 letters from the chairman making allegations against me that were unsubstantiated. The first sent last Friday alleged that I was insisting on immunity for Ms. Lerner when, in fact, I was attempting to obtain a proffer. The second sent yesterday alleged that I somehow conspired with the IRS to target True to Vote, when, in fact, the documents show very clearly that we were requesting public information, and I asked unanimous consent to place into the record my 2 responses to those letters. One I sent yesterday to True to Vote, with regard to True to Vote, the one I sent this morning.
Without objection, both the letters to you and the letters from you will be placed in the record.
I'll yield to the gentleman.
Thank you.
The gentlelady yield to the gentleman from Nevada.
Mr. Chairman, I do. Thank you.
Okay, gentleman is recognized.
Thank you, Mr. Chairman. I oppose this resolution by Chairman Issa. And you know what? I've
tried to listen every day. We've had a hearing on this to my colleagues from the other side. I have listened to the witnesses who came forward to offer testimony with an empathetic ear because they feel that they were affected by the targeting of the IRS. But my colleagues on the other side, I think you may have misplaced the blame here. The only reason we haven't been able to get the truth from Lois Lerner is because of one person, and that is our chairman. The chairman has refused for more than 9 months to hold any hearings with any legal experts to discuss these issues, demonstrating that he simply does not want to hear from anyone who disagrees with his position. The chairman has refused to hear from any Democratic members of this committee and even cut off the mic of the ranking member and abruptly ended the hearing. The chairman refused to let Ms. Lerner's attorney speak as a proffer for her. The chairman failed to grant 7 additional days to her attorney, which he requested to prepare his client. Instead, the chairman scuttled that offer from Ms. Lerner, and now we are dealing with the situation where she invoked her Fifth Amendment. Now, like many of you, I want to hear from Lois Lerner. I want to get the facts. But because of the manner in which the investigation has been handled by our chairman, we can't get those facts. So if my colleagues want to hold someone in contempt, maybe they should look to the person holding the gavel, since it's his poor handling of this investigation that has resulted in why we can't get the truth that the people deserve. This resolution does nothing to get the truth for those who feel that they were targeted or the public who deserves an oversight committee to act in a fair, impartial, and professional manner. Unfortunately, this has not been the case since day one of this investigation, and I regret it because the American people deserve better. The committee has interviewed 39 witnesses, reviewed more than 450,000 pages of documents, and the IRS has spent at least $14 million so far, and there is absolutely zero evidence to support the chairman's accusations that Ms. Lerner orchestrated any IRS targeting, and some of the questions that my colleagues and I would like her to answer can't be answered because of the manner in which the chairman ran this investigation. I don't like the fact that Ms. Lerner invoked her Fifth Amendment rights, but we as a committee must respect the constitutional rights of all citizens, including those of Ms. Lerner. And so I would hope that my colleagues would understand that there are those of us who want to get to the truth. We just expect the leadership of this committee, the chairman, to allow us to do that in a fair, impartial, and professional manner. And that didn't happen in this case.
We now go to the gentleman from Tennessee, Mr. Desjardins. But before you begin, there are 8 minutes and 55 seconds left on the vote. I will intend to do one more if there's anyone on the minority side before recessing. We will come back immediately following the second vote. The gentleman is recognized.
Thank you, Mr. Chairman. Folks, this investigation is about much more than punishing those who have done wrong at the IRS. And frankly, it's much more about additional scrutiny that those conservative groups receive from a government agency. This investigation is about preserving our democracy, the integrity of our democratic election system, and the First Amendment of the United States Constitution. Imagine just for a moment that a president and an administration in this nation that utilizes systematic power through an agency or department to suppress its political opposition. Imagine that such actions altered an election. Such an occurrence should be extremely unsettling no matter what party is in power. The problem is that without Ms. Lerner's testimony, This committee and this investigation cannot uncover the whole truth, which to this point closely resembles these aforementioned acts. The focal point of this investigation is to prohibit even the appearance of the IRS political suppression from ever occurring again. Just for a moment, I would like to reread the Oversight Committee mission statement that Chairman Issa does at the beginning of every hearing, because I believe it is vitally important in how we as its members conduct our business. We exist to secure two fundamental principles. First, Americans have the right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. We will work tirelessly in partnership with citizen watchdogs to deliver the facts to American people and bring genuine reform to the Federal bureaucracy. Without Lois Lerner's testimony, this committee and its investigation are at a standstill. The American people are unable to ascertain their right to know what they have gotten from their government, and many questions still remain. Ms. Lerner claims she has done no wrong. She further claims if she testified, she would not incriminate herself. There is an ongoing debate as to whether Ms. Lerner waived her Fifth Amendment rights when she first appeared before the committee. I believe, much like my colleague from Tennessee, Mr. Duncan, who reiterated this point earlier this morning, in the danger of the precedents Ms. Lerner's actions set. If every defendant claimed innocence and then proceeded to plead the Fifth, investigations and testimony would never be able to proceed. Every defendant would follow such action, and our judicial process would come to a standstill. I hope that this committee and every single member will do everything in its power to seek the truth. Ms. Lerner's testimony is essential to this end, and I believe this committee has given Ms. Lerner and her counsel ample opportunity to come forward and avoid contempt charges. Yet she still refuses to do so. The committee's hands are forced, and we have no choice but to hold Ms. Lerner in contempt so that this investigation can give the American people what they want, the truth. And for the sake of this Republic, I hope we give them just that. I yield back.
I thank the gentleman. Since we have no further individuals asking for recognition at this time, but I understand there will be some returning. Ms. Loomis, you haven't taken your own time. Do you wish to be seen at heard at this time?
I wish to be awarded my time and choose to yield it to another member.
Oh, so we will recess until approximately 5 minutes after the second vote, not after it ends, after it begins. We stand in recess.